Two issues here. Did INEC act properly? And I have, let me first of all qualify whatever I'm going to say. I have not read the whole judgment of the Court of Appeal, but I have read the order of the court. So I'll limit my comments to the order of the court and also to the what is in the public domain. I understand that the judgment came from an interlocutory appeal, the issue of jurisdiction of the Federal High Court to entertain the matter. So the substantive matter, as you rightly observed, is still pending before the court. So we also have to be very careful about how we speak about issues concerning this so that we don't also fall afoul of the law by commenting on substantive issues that are yet to be determined by the court. Having put in that rider, let me put it this way. I think I disagree with the conclusions reached by the commission. The chairman of the commission is a respected academic, a lawyer, and a senior advocate of Nigeria, so has obtained the highest recognition in the academia and also in the profession as a senior advocate. And I know there's a very vibrant legal department in the commission as well, and it has boasts of at least 3-4 senior advocates of Nigeria. I want to think they carefully studied that judgment. But in its extrapolation, its interpretation of that order, I have reservations about that. Because the court did not say that INEC should withdraw recognition from either faction. It never did say so. All it said was that it's which everybody, all parties, not just at INEC, but all parties to the action, which is INEC and the contending factions, should ensure they don't do anything to render nugatory the likely judgment of the court. So don't do anything that will usurp the powers of the court and its ability to do justice in the matter. I don't see how, if I was to advise the ADC, for example, I think they should proceed with all the actions they are taking as long as they don't impugn on the majesty of the court and its ability to do justice in the case. What do I mean by this? Now, there's a convention planned, and there's one faction planned. I don't know whether the other faction is also planning the convention. Whether INEC attends that convention or not does not necessarily invalidates the convention, the Congress and the convention, and its outcome. What the law says, what the Electoral Act says, that you notify INEC at least 21 days to the holding of your Congress, for holding of your convention. If you don't do that, then INEC has the power to, by itself, go and attend and monitor what is going on there. The essence of the monitoring of the convention is not to give validity or to withhold validity from the Congress meeting or convention. It is just to ensure that if a dispute arises, then the courts can look at the INEC report and take it as the report of an independent, unbiased person observing proceedings, and the likelihood is that it will believe what is contained in that report. As to whether I see that the commission has also replied to the ADC in terms of whether the chairman should be removed or sacked. And it was a very prompt reply. I read that late hours of this morning. And they made allusions to the fact that there's a process or a procedure for removing a chairman or any member of the commission. And rightly so, there is a process, constitutional process. I'm not too sure that the David Mark-led ADC is asking the president to act outside the scope of the constitution. We are all guided by provisions of the law. Both INEC and all the contending parties should be so guided. Okay. The essence is to preserve the rest. What is the rest? The rest is the party. And we don't, sorry, I'm just going to conclude by saying on this point, by saying that, look, the law does not envisage that at any given time there will be no leadership in the party. There has to be. INEC monitored the meeting which led to the David Mark election or selection, whatever it was, and had given recognition. So the question is, what is the status quo ante bellum? What was the status quo as at the time the disputes went to court?